Morning, everyone, and welcome to our inaugural webcast. My name's Paul Reeves. I'm a partner at Stevenson Harwood, and I'm joined today by my colleague, Natalie Edwards.
Hello.
Natalie and I are going to talk about redundancies. And in the current climate, notwithstanding the government's help and support to businesses, businesses are now starting to look at what ways they can reduce costs and create efficiencies. And one of the largest costs for employers is their workforce. So inevitably, this means that redundancies are never far from employers' minds at the moment. So what we will do in this webcast is we will look at the redundancy exercise through a series of questions and answers. So what do we mean by redundancy? Under the statutory definition, an employee is dismissed by reason of redundancy if the dismissal is wholly or mainly attributable to one of the following: a business closure, i.e. they close the whole business down, place of work closure, for example, where you relocate your business elsewhere, either within the UK or globally, or there's a reduced requirement for employees carrying out a particular role, and that has ceased or diminished. So this is what we would normally refer to as a role-based redundancy. So if redundancies are necessary, for the reasons I've just outlined, an employer has a consultation obligation. So is there a minimum or maximum period of consultation? Well, the short answer to that is no, there's not. There's no minimum or maximum period for which employers should consult with their staff. If you think about it, if employers did that, or did have that obligation, there'd be a desire to kind of run down the clock sometimes just to get through the process. So the government doesn't impose any minimum or maximum. So various obligations, depending on the numbers involved. So if you've got less than 20 employees at risk of redundancy, then there's no collective consultation obligation, and we'll come into a bit more detail later about what collective consultation means. But instead, you must carry out individual consultation with the employees at risk. And as I've said, there's no minimum or maximum time frame for this, but in all circumstances, any consultation must be meaningful. And again, we'll come back to what does meaningful mean in a second. If, however, you've got between 20 and 99 employees at one establishment, and an establishment is defined, and Natalie's going to cover that shortly, who are at risk of redundancy in a 90-day period, then you do have a collective consultation obligation. And this means that the consultation must begin at least 30 days before the first dismissal takes effect. So you can give notice during that period, but the dismissal can't take effect within 30 days of you starting your collective consultation obligation. If, however, you've got 100 or more employees, then the definition that I've just talked about is not 30 days, but instead is 45 days. So the first dismissal can't take place from 45 days from the start of the consultation period. Again, you can still give notice during that period. Also note that I mentioned the 90-day period here. It may be that redundancies happen in stages, with small numbers being made redundant over a period of months. But if the total number of redundancies over a 90-day period meet the thresholds I've just talked about, then the collective consultation obligation bites. So what you can't do is you can't do 15 in the first month, 15 in the second month, 15 in the third month, and think that you're below the threshold of 20. You would aggregate all those numbers together. So what we're going to do next is we're going to consider how an employer should determine which roles should be made redundant. Natalie.
Thanks, Paul. Okay, so to start with, employers need to decide what structure they're trying to achieve and then consider what roles and skills are required for that new structure. So it could be a very straightforward exercise in that an entire work stream is no longer required, and therefore it's clear that all employees in that particular work stream are at risk of redundancy. Or it could be more complicated and a general look across the workforce to determine which roles should be eliminated. Employers must select employees for redundancy in a fair way and be sure not to discriminate against any individuals based on, for example, their childcare obligations, their proximity to retirement, or the fact that they work part-time. During the coronavirus pandemic, employers must not select employees for redundancy simply because they're shielding or they're furloughed. That's very relevant at this time. It is good practice to assess all employees against the selection criteria to determine who will be made redundant. And this criteria could include things like the quality of work, qualification or experience, attendance record, and disciplinary record. You should consult with employees to gain their input on what that selection criteria will look like. The more open and collaborative the selection process is, the more employees will trust that it's fair. It's always worth remembering redundancy is a proposal to be consulted on. Those employees who've been selected as a result of this exercise are not yet redundant. They're at risk of redundancy, and the period of consultation will be used to explore ways in which their redundancy might be avoided. Earlier, we talked about the number of redundancies in a single establishment which trigger collective consultation obligations. So let's focus a little bit on what an establishment is. Case law states that an establishment is the unit to which the redundant workers are assigned to carry out their duties. Now, you'll remember the disappearance from our high streets in 2008-2009 of Woolworths and its great pick and mix selection and vinyl record section. The closure of Woolworths meant redundancies at each of its stores. In considering whether collective consultation obligations were triggered, the question there was whether each store was its own unit or establishment, or whether all the stores should be taken as a whole and treated as one establishment. The courts held there that in a mass redundancy exercise across a number of stores, each store can be counted as an individual unit, which meant that each store could be viewed in isolation, and if less than 20 employees were affected, a collective consultation would not therefore have to have been undertaken at that store. However, it's very fact sensitive as an assessment. Whilst it does give comfort that multiple store closures or redundancies across various sites may avoid the need to collectively consult, you obviously need to apply your mind to this in advance of that exercise. So this leads us on nicely to collective consultation obligations and considering how an employer should get started with that process. Okay.
Thanks, Natalie. So where we've got an obligation to collectively consult, then you must do this with either appropriate representatives of those affected or the individuals directly. So what do we mean by this? Well, the affected employees are those who may be affected by the proposed dismissal or who may be affected by the measures taken in connection with those dismissals. This term extends beyond those immediately at risk of dismissal and could include the workforce, for example, who may be taking on additional responsibilities if the dismissals go ahead. Appropriate representatives. So who are these? Well, this could be a recognised trade union if you have one. Don't worry if employees are members of a trade union, but the union isn't recognised. You wouldn't need to bring the trade union into this exercise at that time unless you wanted to. If you don't have a trade union, then individuals have the statutory right to elect representatives to act on their behalf, or you may already have a body established to deal with this type of scenario, so an established body that has a remit to cover collective consultation. So let's talk briefly about the election process. So assuming you have none of the either a trade union or an elected body, individuals have the right to elect representatives. And this is something that often gets overlooked when planning the timeline for a redundancy exercise. So it's vitally important that you build in at least a week, maybe longer, to appropriately carry out an election process. The employer must make arrangements that are practicable, reasonably practicable for a fair election. It's for you to decide how many representatives you should be elected. This can be based on the number and classes of affected employees, but as a rough rule of thumb, you'll want approximately 15 employees per representative. And I would always advise that you have a substitute representative who can step in should the elected rep either be ill or may be made redundant in an early round of a redundancy exercise. So you need to have that substitute to ensure that the process either doesn't get frustrated by having to re-elect someone or is paused because the elected rep isn't around. All candidates must be, of the affected employees, must be given the right to vote, and no one should be excluded who is an affected employee from standing as a representative. And then all people who are affected by the redundancy have the right to vote on the day. So far as possible, you should ensure that there is fairness in the counting of the votes. Sometimes this is outsourced to a third-party body, but you don't need to do that if you can ensure the fairness so people can vote in secret. Then there's somebody who will count the votes, and there'll be an independent person from within the business who will check those counts. There's no specific time frame for when the election can take place, but as I said earlier, you do need to allow at least a week to invite nominations and then to be able to carry out the elections. Now, at the moment, that should be relatively easy because with people working remotely, you could do this via email if you needed to. But the one thing that consultation cannot do, it cannot start until your representatives have been elected. Now, we often find in these scenarios, depending on the numbers, that even if there is a collective consultation obligation, employees prefer to hear the message directly from management. That's fine, but you need to give employees the choice between electing representatives or to hear the message directly as a group. What I'm going to move on to now, I'm going to have a recap as to what an employer has determined that redundancies are necessary and its collective consultations obligations have been triggered, reps elected. There's one additional and important task at this point. You, as the employer, where you've got your collective consultation obligation, must notify Secretary of State for business innovation. And this requires you to notify the Secretary of State on what's called a HR1 form. Now, the form is relatively straightforward. It's asking for very basic factual information about what may or may not happen with the redundancy. For example, have you elected reps? When's the date of the first dismissal? What's the date of the last dismissal? And then it asks you for a breakdown as to the categories of employees that may be impacted by this. Now, the form may seem relatively simple, but the consequences for not complying with this statutory obligation can be quite dire, because it's a criminal offence with an unlimited fine for the directors of the business. So our advice is always to make sure that the HR1 form is completed and submitted at least on the day that the collective consultation starts. It should not be done later, because those 30 and 45 days I mentioned earlier, they will start to run from the date that the form is submitted. So it's always advisable to submit the form at the same time that you start your collective consultation obligation. Over to you, Natalie.
Thank you. So thinking next in more detail about collective consultation, let's consider what the aim of this process is and what exactly needs to be done. So firstly, it's worth noting that consultation must be undertaken with the aim of seeking the representatives' agreement. In reality, it might not be possible, but the employer should keep this in mind. So let's look at the two stages. Stage one is the provision of information about the proposed redundancies to the reps in writing. This information includes the reason for the proposed dismissals, the number of employees affected, and what the calculation of redundancy pay is. Consultation will have commenced at this point, as long as the employer has provided sufficient information to enable meaningful consultation to take place. But obviously, you can continue to provide further information throughout the consultation process as relevant or as needed. Stage two is the process of consultation itself. So once that information is provided, you then move on to consultation. So the consultation must be fair, which means an open and detailed discussion on the proposals, sufficient time for response, and a willingness on the part of the employer to be persuaded. The subject matter of consultation must be with a view to reaching agreement with the appropriate representatives on the ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of dismissals. Now, obviously, an employer is not required to agree to any counter-proposal made by the representatives, but the process of consultation is akin to a negotiation. It's not, therefore, sufficient for the employer to simply explain its proposals and listen to any counter-proposals. An unwillingness on the part of the employer to seek agreement could be seen as a breach of the requirements and lead to a protective award being made by a tribunal. Only after this consultation process has taken place can you confirm the dismissals by reason of redundancy. So why is all of this important? Well, because the sanctions for failure to meet the collective consultation obligations can be extremely costly. An employer that fails to meet its obligations faces a protective award of up to 90 days gross actual pay for each affected employee, and that can obviously be a significant sum. So this isn't a capped amount, this is actual pay. Now, tribunals will start at the 90 days as an award and work backwards, discounting for any meaningful consultation that has actually taken place. It's also worth remembering that you can't settle a protective award claim under a settlement agreement, only a COT3 via ACAS.
Okay, Natalie, thanks for that. So let's assume that you've gone through the process and unfortunately you now need to confirm employees are redundant. What is it that you have to pay to those individuals? Well, you have to obviously satisfy your contractual obligations. So you need to pay any notice sums, check your pay in lieu of notice clause. Is it pay in lieu of notice of salary only, or is it pay in lieu of notice of salary and a sum in lieu of benefits? You obviously need to pay for any accrued but untaken holidays. Sometimes your contracts will provide that holidays can be taken during the notice period. So if you want people to either go on garden leave during the notice period, you might want to use that period to run down some of the holidays. But bearing in mind in the current climate, individuals will be keen to ensure that they receive the maximum payment possible. So your staff will be probably more keen to receive a payment in lieu of notice. Then when we get to the redundancy payments, you obviously have to pay a statutory redundancy payment but only if the individual has 2 years service. If they have less than 2 years service, there is no statutory right to a statutory redundancy payment. And on the slide, we've set out there what the formula is. It's dependent on length of service, a week's pay, which is determined each April by the government, currently at £538 per week. And then there's an age multiplier, depending on your length of service and your age. That is the multiplier that is applied to the formula. Quite often, though, employers want to pay above the statutory redundancy formula, and for that, it's entirely up to you what sums you offer to the individual. In our experience, we generally see multiples of weeks pay. This is usually somewhere between 2 and 3 weeks, but some are more generous than that. What we would advise, though, if you are paying people an enhanced redundancy sum, that you consider whether you want to get that covered by a settlement agreement. Now, obviously, if there's a settlement agreement, the individual needs to take legal advice, and where you've got a significant number of people, that might be logistically quite challenging. But because you are paying over and above what you're required to do, you may want to go down that path to give yourself certainty that there is no comeback from any of those individuals. Genuine redundancy payments, where the statutory are enhanced, do benefit from the first £30,000 being tax-free. Obviously, sums over £30,000 are now subject to tax, as they've been for a number of years, and also employer national insurance, which has been applicable since April this year.
Okay, thanks, Paul. So we've just touched there on employees with less than 2 years service not being entitled to a statutory redundancy payment, but moving on to just a word of caution on those employees. It's a common misconception amongst employers that dismissing an employee who doesn't have 2 years of service will mean that they're safe from the employment tribunal claim. However, there are certain claims with no service requirement, for example, discrimination and whistleblowing claims. In addition, it's worth remembering that those with under 2 years service do still count towards the numbers which trigger collective consultation obligations. So where we talked about 20 or more dismissals in a period of 90 days. So whilst it's tempting to fast track dismissal processes where the individual has less than 2 years service, and in some situations it is appropriate and legitimate to do so, employers should always keep an appropriate paper trail in order to demonstrate that the reason for dismissal was not unlawful. So finally, having covered the process of redundancy, let's briefly turn to how employers can minimise the reputational risk of making those redundancies. So obviously this is a time where there's likely to be a great number of redundancies, and there will be a great deal of press scrutiny regarding how those redundancies are being handled. You must therefore carefully follow the procedure we've outlined today to meet your legal obligations. But in addition, you should consider if there's anything you can do to soften the blow for the redundant employees who are obviously facing a very difficult job market. You may have seen recently the CEO of Airbnb made an announcement that the company would be making 1,900 employees redundant, 25% of its workforce, a brutal blow to its people. However, in order to help those redundant employees transition into unemployment, they've promised extended healthcare beyond employment, have told redundant employees they can keep their laptops to help with their job search, have dedicated their internal recruitment team to helping those redundant employees find jobs elsewhere, amongst other things. Now, these actions, although at some cost to the employer, do provide a positive image on what would be perceived as a very negative exercise. Other actions, which might perhaps cost slightly less, but you could consider, include offering counselling, outplacement services and CV workshops to redundant employees to assist them in finding a new role. So we hope that that's given you a good understanding of your obligations on redundancy. If you have any questions, please do contact Paul or I, or your usual Stevenson Harwood contact. Thank you for watching.